Good morning, sir. You're Patrick Gallagher. And Mr. Gallagher was previously in court, entered a plea of guilty to driving while intoxicated, third or more. And I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor, yeah.
Are there any additions or corrections?
Nothing was mentioned.
I didn't see any, Your Honor.
So, Mr. Gallagher, you want to know what my big concern is? How long were you off probation for your DWI second when you got your DWI third?
I can't remember.
4 days.
4 days.
That's what it looks like to me. It expired, community supervision expired, looks like October 3rd of 2024 is the way this reads. New case, October 7th of 2024. What, if anything, have you done with regard to any kind of drug treatment? Anything on your own to stop using alcohol or drugs?
I quit drinking and I pray to the good Lord because I'm a single dad with grandkids, so that's over with.
Well, it should have been over with when you were on probation last time.
Yes, ma'am, I agree.
And I appreciate that you're praying, but sometimes that's not enough.
I agree with that too.
Are you still working
Yes, ma'am.
at Exxon?
Yes, ma'am.
Judge, there is one issue I need to bring up whenever you're done.
Go ahead.
I'd spoken to the prosecutor about this. He is a full-time shift worker, and one of the issues was he had brought in his work schedule as he was, if the court was willing to, he had dates that he was not working to do the 10 days.
Okay.
And that is something I would bring the court's attention.
Sure.
Oh,
Thank you.
you weren't quick enough. You were quick, though. Okay.
It was the highlighted dates is when he is not working that he was asking the court to. I know he knows it's a big ask, but
Well, I mean, I don't know. It kind of is. It kind of isn't. Typically, I let people who are working do it on weekends. This is just how the weekends
I have no
for his
issue
weekends.
with the erratic nature. of it.
Here's the more, I guess, the part that's going to be potentially something that you're going to have to really figure out with your job schedule, and there's not going to be any excuses, is that you're going to have to enter and successfully complete the JCDI program. It is an intensive outpatient program. You're not the only patient that will have to do it on this type of schedule, but you're going to get started on that immediately without any mess ups, because if so, you're right back in here and you're going to be looking at going to prison. Do you understand?
Thank you.
So what I'm going to do then, Mr. Gallagher, is find that you entered your plea of guilty freely and voluntarily. Have you been wearing a drug patch either, or no? Was that a condition of anything? I didn't,
no judge.
the bond, it wasn't a condition? Well, because there was, the blood came back with positive of Delta 8 THC. I'm sorry.
That's correct.
Yeah. Are you doing anything like that still?
No, ma'am, I work for ExxonMobil.
Well, I mean, did you work for them when you,
I did, but I had a vape that I didn't know was there, so that's history.
you're 52 years old and you're using a vape that you don't know what's in it? Do you want me to buy that?
You don't have to, no, ma'am.
I don't. Because if you don't know, then you should have known. So either way, it's ridiculous that, I mean, that's something that a teenager would come in and tell me, I got a vape and I don't know what's in it. All right, I'm going to do this. Going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time follow your agreement. Find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement. Well, actually, I'm not going to follow the agreement with regard to the length of time on probation. The fact that he was just off of probation, I think warrants longer than a 5-year probation. The length of your probation period is ultimately up to me anyway, so it's not like I'm following the main part of the deal, but you still wouldn't have a right to appeal because that's up to me. So I'm going to find you guilty, sentence you to 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that and place you on probation for 7 years. You're ordered to follow all of the rules and conditions of probation. That's going to include entering and successfully completing the JCDI program and following, obviously, all of the rules and conditions. You'll have an auto ignition interlock device on your vehicle. Do you already have that? You're going to keep that at least for some amount of time. And if he has the interlock, you can make a notation. I don't need interlock and scram and portable, whatever they feel like is best through JCDI. Once that gets going, I'm fine with. I am going to order that you serve the 10 days upfront time. That is going to be on the date starting, I'm going to attach, I'll give you this copy as well, but so like where it says 9 nights, you work that night of the 9th.
It's like, I'm all right.
So, so you'll start on October 10th. I want you to turn yourself in October 10th at 6 p.m. And then you'll spend the 10th and the 11th, and they'll release you on the 12th. Okay?
Yes, sir.
And then when you work days, what time do you get off?
4 o'clock.
4 o'clock p.m.?
Well, depends on when I leave, so it could be 4 to 4:30 to 5.
Okay, so the next time is going to be, since you're working days on the 16th, you're going to go at 6 p.m. on the 16th, and then you'll spend that night, the 17th, and get out on the 19th. If you don't have something written, days or nights, does that mean you're off?
And when it's so short-handed, it's a possibility, or I had to work overtime because I gave up 2 days overtime already for the 11th and 17th.
Okay, if it doesn't say days or nights on this calendar, does it mean you're
Yes,
off?
ma'am.
Okay, so that second one in October, you're gonna go, we're gonna get this done. Because that's your long days off. So we're gonna get that week done. So you're gonna go in on the 16th, and you're gonna get out on the 23rd. So that gives you one overnight, 16th, 17th, 18th. That gives you 7 days. And then that first one only gives you 2 days, so that's 9.
So you're saying go in on the 16th when I get off work that day?
Mm-hmm.
Okay.
And we're just missing 1 day.
There's 7 November on the back of it there.
No, we're getting this will be done in December, so you're gonna then go in on the 28th
Yes, ma'am.
at 6 p.m. and you'll get out the next day, and that'll take care of that last day. So, and then Anna will probably need that too. Make sure you get all of those done. Okay, all right. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rennick. You need to have a seat here in the courtroom and wait for probation to call you up. She'll call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Yeah. What was it? $500 fine is obviously part of that as
Yes,
well.
sir.
Yes.
Thank you, Your Honor.
Emily, good morning. Are you Xavier Clayton? And Mr. Clayton was previously in court and entered a plea of guilty to the second-degree felony offense of assault on a peace officer. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
I have, Your Honor.
Any additions or corrections?
The only correction I would have is that he is remorseful for what happened. That's it.
Judge, of course, I'm aware that the court is probably hesitant to plead with the criminal history. The offer was made based on the fact that it dates back to 1995.
Right. Okay. All right, so, Mr. Clayton, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That includes that you're going to be on the high-medium caseload, at least for some amount of time. You will be required to begin a program for anger management within 60 days of the beginning of your probation, and to follow all of the other rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this felony conviction on your record. And if you successfully complete the probation, at the end, the case will be dismissed. You will not ever have this conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be found guilty of the offense, so you would have the conviction, and you could be sentenced anywhere in the range of punishment, which is a minimum 2 years up to 20 years in prison. Do you understand? And I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. And then it looks like there will be a dismissal in 24 DCCR 2206 as part of this, and I'll sign it as soon as it comes through. If you'll just have a seat here in the courtroom, sir, probation will call you up when she's ready to go over your paperwork, and so just watch for her to call your name, okay? All right, thank you. And then Sierra Jackson, Mr. Adams.
We reached a deal in that case.
Okay, I'll hold it while y'all do the paperwork.
Well, no, it's not gonna be.
Your Honor, what we agreed on is a dismissal for restitution. She's got to get the money, so whatever time she needs to get that.
I think it was 680.
653.99.
653,
So it's been pending and it's been on the trial docket now for months. And when I put it on the trial docket, I say there's not going to be deals. So that $653 should have been something that she was saving up for something like this. How long is it going to take?
Next week, because I'm unemployment.
We reset 1 week if you don't mind, and then we'll just have the money here, the money order.
Here's what I'm going to do. I'm going to number it for trial for Monday at 1 o'clock. So y'all be here Monday at 1 o'clock. If it gets taken care of, great. Otherwise, it's going to be in the number and go forward with
We
trial.
have it for Monday.
Okay, Monday at 1 o'clock.
Monday, 1 o'clock.
All right, see y'all then.
659.
659.
Okay,
Just say 660.
okay.
Good morning. Are you Carl Ross?
Yes, ma'am.
And Mr. Ross was previously in court and entered pleas of guilty in cause number 25 DCCR 0093 and 0094 to the second-degree felony offense of collision involving death and the third-degree felony offense of collision involving serious bodily injury. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor, we have.
Are there any additions or corrections?
No.
Not from the state, Your Honor.
Mr. Ross, are you still working at TAS?
Yes, ma'am.
Okay. All right, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. However, I'm going to follow the agreements that you made with the district attorney. In cause number 25 DCCR 0093, I'm going to defer all proceedings and place you on probation for a period of 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. In cause number 25 DCCR 0094, also defer all proceedings and place you on probation for a period of 10 years. Order you to pay a $1,000 fine and to follow all of the rules and conditions of probation. I am going to order, but hold in abeyance, 180 days upfront time in each of these cases. And what that means is that if there is anything at all that happens at the beginning of this probation where you're not following the rules or anything at all that probation feels like isn't going according to the plan, then I have already ordered 6 months in jail upfront time. The seriousness of what happened and what you did and the fact that you left is just, it's awful. And so The fact that you're working, I think it's important that you continue that, but I'm not going to worry about that at all if you're not doing everything perfectly on this probation. Do you understand? If you follow all of the rules and conditions of probation and you do everything that you're supposed to, the opportunity that you're being given today is huge. You're not going to have these felony convictions on your record. And at the end of the cases, if you successfully complete the probations, the cases will be dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you will be brought back into court. You can be found guilty of both of these offenses, and in one, you could go to prison for up to 10 years and the other for up to 20 years. Do you understand? I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. Good morning, you're Benita Graham?
Yes, ma'am.
And Ms. Graham, did you get a lawyer hired?
No, ma'am. I did visit with,
Who'd you talk to?
I talked to Kendra, Ms. Holmes, and, Attorney Adams.
Okay.
And he did state, Attorney Adams did state if he was elected that he would, represent me pro bono.
Okay, so, well, what do you mean if he was elected? I don't.
Well, if you assigned him to my case.
Oh, yeah, it doesn't work like that.
Okay.
Okay, so are you working?
No, ma'am.
Okay, why aren't you working?
I'm retired and I only have one source of income, and that's, Social Security for my husband's death.
Okay. All right,
And I
so,
do have cancer.
okay, so what I'm gonna do this morning, Ms. Graham, is have you fill out some paperwork. Thank you for doing what I asked you to do, to see if, I'm gonna have you fill this paperwork out to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely, don't leave it all blank or put zeros, and then I'll take a look at it when you're finished. If you'll step over in front of the clerk, she'll give you that information. Good morning, are you Joan Kraus?
Yes, ma'am.
And Ms. Kraus, this is your initial appearance in cause number 25 DCCR 0904. You're charged with the third-degree felony offense of driving while intoxicated, third or more, from July 16th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I got a court appointment.
Right, so when you're in custody, we automatically give you a court-appointed lawyer. If you make bond, I expect you to at least try to hire your own lawyer. Are you working?
No, ma'am.
Okay, why aren't you working?
Retired.
Okay, and so you have a retirement income?
Yes, ma'am.
So what I'm going to do, Ms. Kraus, is reset your case to give you some time to try to hire a lawyer. Okay, you need to, if you get someone hired, bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options.
Okay.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
I do, ma'am.
And are you, do you have the ignition interlock device on your vehicle?
No, ma'am, I don't have one.
You're not driving. I want to make sure you understand it's a condition of your bond. You cannot drive unless you have that on your, any vehicle. Do you understand?
Yes, ma'am.
Okay, step in front of the clerk. She'll give you your reset notice. Sarah Henderson. Good morning. You're Sarah Henderson?
Good morning, yes, ma'am.
And Miss Henderson, did you get someone hired?
No, ma'am. I got 3 people, but my income kind of changed. Because I'm trying to see if I can maybe qualify to.
Who'd you talk to?
I talked to Langston, Scott Adams, C.L. Swisher, and Keith French.
Mm-hmm. Okay. And what do you mean your income has changed?
Well, I switched jobs and I'm making a little less. You know, but at first I was making too much to get one the last time I was here.
Mm-hmm.
But I'm trying to see if maybe I qualify to get a court-appointed lawyer now.
Why did you switch jobs to make less money?
Well, I didn't really have a choice, you know, so
Okay.
I didn't want to switch.
Where are you working?
The city of Ohio,
Okay.
streets and drainage.
Okay. So I'll let you go ahead and fill out that paperwork again. Make sure you fill it out accurately and completely, just like you did last time, and then I'll take a look at it. Okay? Step in front of the clerk. Good morning. Are you Janisha Jackson?
Janisha Jackson.
Janisha, and Ms. Jackson, this is your initial appearance in cause number 25, DCCR 0903. You're charged with the second-degree felony offense of abandoning or endangering a child, and that's from May 20.
This is one of the most powerful probation warnings you'll hear in a courtroom. The judge is deferring proceedings on two extremely serious cases, collision involving death and collision involving serious bodily injury, but she's doing it with a safety net in place. 180 days of front jail time already ordered and held in abeyance. Here's what that means legally. Deferred adjudication avoids conviction for now, but if probation is violated, the court can immediately impose punishment within the full statutory range. In one case, that's up to 10 years. In the other, up to 20. And the judge has made it crystal clear. Perfection is required. Emotionally, you can feel the weight of this decision. Someone died. Someone was seriously injured. And the fact that the defendant left the scene compounds it. So ask yourself, is deferred probation here an act of mercy or a final warning before prison becomes inevitable? Let's move forward.
And that's from May 26th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, not yet.
Okay, so what I'm going to do, since you've made bond, is I'm going to give you about a 30-day reset to give you some time to try to hire a lawyer.
Okay.
If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Yes, ma'am.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail.
Yes,
Do you understand?
Yes.
All right, step in front of the clerk. She'll give you your reset notice. Presley Viltz. Good morning, you're Presley Viltz. And Mr. Viltz, did you get someone hired? Who'd you talk to?
Scott, King,
Speak up, please.
Scott, and
I can't hear a word you're saying.
Kimberly, James.
James who? Okay. So where are you on being able to get one of them hired?
I just started taking back on work.
Okay, where do you work? Say? Okay, so what I'm gonna do, thank you for visiting with those attorneys. I'm gonna give you one more reset, see if you can get some funds together to hire one of them or anyone else. If you get them hired, bring that reset notice. If it's not gonna work out with one of them, talk to 3 others, bring me those names, and we'll discuss your options if you're still unable to hire someone, okay? So make sure you talk to 3 others if you don't get somebody hired. All right, step in front of the clerk. Good morning, ma'am. You're Crystal Latulis. And Ms. Latulis, this is your initial appearance in cause numbers 25 DCCR 0850 and 0851. In each of those cases, you are charged, give me a second, with the second-degree felony offense of abandoning or endangering a child, and that's from May 30th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
This is the thing, Judge, Lewis. I'm gonna be honest with you. My child, when I got out, I had no stipulation.
Speak up, please.
When I got out, I had no stipulation, right? So the week that I got out, I got a call from that she said that the child had to be removed from my home. I'm a parent at the end of the day. I have a nursing license interfering with this charge that I have now. That was my whole point of starting over. I already had got my nursing license, but I'm going.
Okay, you're telling me way too much information.
Okay.
Here's the thing.
I was just asking about my child. Is there any type of way that I could get?
You need to get a lawyer, and they can file a motion asking, but just with your word, based on what you're charged with, no, I'm not going to allow that at this point, okay? So I'm going to expect you to try to hire a lawyer, reset your case about 30 days to give you some time to do that. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers you talk to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail.
Okay.
Do you understand?
I don't. He told me something about the version. You just stepped out.
Okay, that's why you need to go hire a lawyer, okay?
Yes,
Step in front of the clerk. Lisa White, good morning. Are you Lisa White? And Miss White, this is your initial appearance in cause number 25, DCCR 0923. You're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from May 24th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am. I talked with Mr. Alvin Samuel,
Uh-huh.
and he suggested price, and that's really important.
Okay, perfect. So what I'm going to do, Ms. White, is reset your case about 30 days to give you some time to try to either get Mr. Samuel hired or anyone else. If you do get him or someone else hired before the next court date, just bring that reset notice to them. They'll tell you what to do. If you're unable to hire someone and if it's not going to work out with him, then I'm ordering you to visit with at least 3 other attorneys and bring me those names so I know you're trying, okay? All right, step in front of the clerk. She'll give you your reset notice. Yeah. Good morning. Are you Donnell Coleman? And Ms. Coleman, were you able to get someone hired?
No,
Did you talk to some lawyers?
yes, ma'am.
Who'd you talk to?
I still have Mr. Ross.
I'm sorry?
Mr. Ross.
Uh-huh.
Ross.
Yeah?
Yes, ma'am.
What about him?
He gave me a deal, like he shot me a deal because they stopped him knocking the door, he still stayed out there and change
Uh-huh.
because my case was hit on my neck.
Okay. Did you talk to some other attorneys or you were planning on trying to hire him? So what I'm going to do, Ms. Coleman, is have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. Don't leave it all blank or write zeros. Put any income you have, any bills you have, and then I'll take a look at it. Step in front of the clerk. She'll give you that information. Jeremiah Paia? Good morning. How do you say your last name? Paye. I feel like we've done that before. Mr. Paye, sorry. Did you get someone hired?
No, I'm still in contact with Mr. Jeff Casey,
Uh-huh.
and I still want to get him hired, so I got a second job in order to do that. You asked me to bring the check stub.
Okay. And where's he from?
I'm not 100% sure, but he's with Jeremy and Jones, that law firm.
Okay.
This is my check stub from FedEx, and I start my new job this week.
Okay. You get paid every week or every 2 weeks?
Every week.
Okay.
But the hours vary from about 20 to 30.
And where's your new job?
It's in the law in Port Arthur.
Okay.
Pivot.
Okay. So I'll give you a little more time. I mean, you're trying and that's great, or I can have you fill out some paperwork to see if you qualify. You want to try that today? Okay. Step in front of the clerk and she'll give you that paperwork. Make sure you fill it out accurately and completely, okay? Kayla Provost? Good morning. Are you Kayla Provost?
Yes,
And Ms. Provost, this is your initial appearance in cause number 25, DCCR 0972. You're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from June 20th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Okay, so what I'm going to do, Ms. Provost, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me the names of the people that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
yes.
All right, step in front of the clerk right here. She'll give you your reset notice. Good morning, you're Patricia Benton? And Ms. Benton, did you get someone hired?
I have not, no.
Okay, who'd you?
I've contacted with Corey, Brittany Holmes, Mr. Macon, and Corey Crenshaw, but I can't go with them.
And you're working?
Yes, ma'am.
Okay, and are you working full-time?
Yes, ma'am.
Okay. So what I'll do this morning, I'm not sure if you'll qualify, but I'll have you fill out some paperwork to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct. And then I'll take a look at it. Step in front of the clerk. She'll give you that paperwork. Yeah.
When I printed this, he had not signed it down and never paid that one form, you know what I mean?
Yeah.
He signed it now.
So the other two
They're on
are,
the tab.
good morning, you're Daryl Spencer. And so, Mr. Spencer, you've been here previously and cause numbers 24 DCCR 1863 and 24 DCCR 0841. And then it looks like there were two new indictments that have come down, and so you now have an initial appearance in those cases. One of them is 25 DCCR 1149, and in that case, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from June 14th of 2025. And then the next one is cause number 25 DCCR 1150. Hold on a second. And in that case, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from June 15th of 2025. And so since you made bond in these cases, have you had an opportunity to try to hire a lawyer?
Yes, ma'am, I had Raquel, he told me he was supposed to be with me today. I teased him last night. He told me he
Okay.
was gonna send a letter to the representative, but I paid him when I came here that Monday. I came and talked to you.
Have a seat in the courtroom. Don't leave until we talk to him, okay?
Yes, ma'am.
All right, go, you can have a seat. Trying to figure out what his bonds are set at, but both of those cases were while he was on bond for other felonies. The two new ones, 1149 and 50, but
Bond tab.
yep. Imagine that, something, the bond information might be under the bond tab.
It's hard for me to understand him, so with your permission, he's got a lot of the money today. The rest of it, he says, will be.
It's coming from the bankruptcy court, because where I used to work, the owner died and they filed bankruptcy. And I talked to him, but I got a letter 2 months ago, said they're allowing me $1,750 for what they were gonna go with. They owed me $21,000.
Judge, if I may, sorry to interrupt, before we get too deep in the weeds, the state's made an alternative offer. The offer is 2 years state jail, or if he pays the full restitution of $2,334, we'll do some form of punishment by county jail. My initial offer was 30 days county jail in the alternative.
Did you bring that documentation?
I forgot it, but they told me I talked to them Thursday.
So here's the thing. Last time you were here, the whole point was to give you time to get this taken care of. It would be something I would think you would think was important to get to Mr. Boudreau or get to me to show that you're getting this money. So forgetting it is something that a kid would do, not a grown man. I'm resetting your case 1 week. You need to bring some documentation, otherwise your case will get taken care of. Hang on, don't talk over me. Otherwise, your case will get taken care of next Monday by a plea, or it will go on the trial docket and there won't be any pleas after that. Okay. See you next week.
Thank you, Judge.
Thank you, sir. Mr. Chason tested negative for everything, so that's good. Thank you. Yes, thank you. I need your signature, though. All right, ma'am, you're Renisha Chason. And will she waive the formal reading of the indictment?
She will, Your Honor.
And again, we're just going to get a plea on the new indictment, reset the MTRP case, and come back and see where we are with the pre-sentence report. Is that correct?
That's correct.
Okay. That goes with that also.
Judge, just to refresh the court's recollection, the co-defendant in this case, who is the, in my opinion, much more culpable defendant, has already pled the TDC time.
Okay, thank you. Ms. Chason, in cause number 24, DCCR 2351, you're charged with the second-degree felony offense of injury to a child, and that's from July 19th of 2024. And how do you plead to that charge?
I plead guilty to the second degree felony offense of injury to a child, and that's from July 19th of 2024. And how do you plead to that charge? I plead guilty to the second degree felony offense of injury to a child, and that's from July 19th of 2024. And how do you plead to that charge?
I'm sorry? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand? And it looks like the agreement that you've made is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, states 1.
It's admitted. Is there any evidence that Ms. Chason not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, but I'm going to reset your case so that the probation department can do a pre-sentence report. And if that can include an update also on the probation case where the motion's filed, so I can have all that information as well, and then we will come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see y'all back at sentencing.
Would the court consider allowing her to remove the drug patch? It's costing some money that she doesn't have.
Not until sentencing. We're going to keep it on until sentencing. Make sure you keep it on and keep it updated, and then if everything goes well, it's about 5 or 6 weeks. Okay?
Maybe excuse me.
Yes, thank you. All right, again, sir, you are Ray No.
Yes, ma'am.
And Mr. No, in cause number, hold on, let me get it pulled up. Cause number 25 DCCR 0386, you're charged with a second-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 0387, you're charged with the state jail felony offense of driving while intoxicated with a child under 15. In the same offense date of December 11th of 2024. And in that case, if you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
I have here on the tablet in each of your cases plea bargain rejections that you've signed with your attorney that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. In the intoxication manslaughter case, that offers for 18 years in prison. And then in the
I think I marked it wrong.
Should be 2 years.
2 years state jail?
Yeah.
No, okay,
Yeah.
all right. Okay, if I make that modification?
absolutely,
Thank you.
Judge.
So in the other, well,
And if you can't read my writing, I'm
nope,
happy
that's
to-
okay. I'm obviously don't know how to erase because now I'm just making marks all over this document. I feel like I know how to.
Should do it.
Okay, so, good grief. It is a Monday. All right, so in that state jail felony case, the offer is for 2 years. In the state jail prison, it would run concurrently with the other case. You have every right to reject these offers and have both of your cases set for trial. I just want to understand, make sure you understand what the possible consequences are if you go to trial, what your options are, and do you understand all of that?
Yes, ma'am, I understand.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am, I do.
Okay, we'll get that done. And Mr. Coleman, is there any reason to believe that these offers would change? Is there any evidence that you're waiting on or anything like that?
No, yeah.
So I do want to make sure you understand that after today, Mr. No, I won't accept this plea agreement. If you change your mind and want to enter a plea of guilty, that would be to something different or open to the court, unless there's new evidence that your attorney or the district attorney gets or finds out about between now and then. Make sense?
Yes, ma'am.
Okay, we'll see y'all at trial. We'll get it placed on the trial docket.
Thank you, Your Honor.
Thank you.
Your Honor, may I be excused?
Yes, sir, thank you. Good morning, ma'am. You're Crystal Calvillo? And Ms. Cavalo was previously in court and cause number 24 DCCR 2456 entered a plea of guilty to the state jail felony offense of theft of property. I've received that pre-sentence report. Any additions or corrections to that report?
No, for the state.
All right, ma'am, I'm going to find that you entered your plea of guilty previously, freely, and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the felony conviction on your record. And at the end of that probation period, if you successfully complete it, the case is actually dismissed and you will never have that felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and then you could be sentenced anywhere in the range of punishment, which is up to 2 years at a state jail prison. Do you understand? And there's no restitution, correct? Okay. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation, she's going to call you up to her desk when she's ready to go over all of your paperwork.
Thank you, ma'am.
Good luck to you, ma'am. Thank you, sir. Good morning. Are you Cameron Gutierrez?
Yes, ma'am.
And Mr. Gutierrez was previously in court and entered a plea of guilty to evading arrest or detention with the use of a vehicle in cause number 25 DCCR 0325. I've received that pre-sentence report. Have you both had an opportunity to review it?
Yes, Your Honor.
Yes, sir.
Any additions or
None
corrections?
from the defense.
Not for the state.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation.
Yes, ma'am.
Today's docket showed the full spectrum of criminal court, from repeat DWI offenders facing stricter supervision, to violent felony defendants receiving deferred adjudication, to first appearances where the court emphasized personal responsibility in hiring counsel. We saw probation extended beyond the negotiated term because of timing and prior history. We saw jail time structured carefully around work schedules but still enforced. We saw defendants warned that one violation could convert opportunity into prison time instantly, and we saw others granted deferred adjudication, a second chance that disappears the moment conditions are violated. Every ruling reflected one consistent message from the bench: compliance matters, preparation matters, and accountability matters.
Probation.
Yes, ma'am.
If you do that, this is a great opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end of the probation period, the case will be dismissed and you'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, which would make you a convicted felon, and sentenced to prison for anywhere in that punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Thank you.